outlining the fifth issue of our lection, procedural options, you need to know next information, that arbitration procedure provides for the parties the right to participate in the trial. Like, it's not official trial, as you know, but in the trial, I will say this, or in the hearing of the case, personally or through the parties' representatives. Parties can file challenge, present evidence, present counterclaims. The defendant may present counterclaims. They can initiate the examination, and they have a lot of procedural options and possibilities. What is interesting that the burden of proof in arbitration hearing lies on both sides. So each party should prove the circumstances to which it refers as a basis of its claims or objections. It's the same in our courts, like official courts. Actually, the problem of collecting evidence during arbitration procedure is very interesting. None of all existed procedural courts, non-economic courts and no civil procedural courts provides the way of collecting evidences in the arbitration procedure. So the requirements of the reliability of evidence cannot be applied. And many scholars in their books write that the examination of witnesses during the arbitration procedure is also very vital and relevant issue. This is primarily due to the fact that legal acts do not stipulate the criminal liability to the witnesses who testified in the arbitral hearing, and it can lead to the abuse of the rights of parties and to the non-truth testimonies. One more feature for the arbitration hearing is that it is not limited by time. As you know, economic procedural court and civil procedural court provide us limitations for the time hearing, but not the act for arbitral tribunals. From the one side, you can say that it is positively, as such optionality allows arbitrators investigate all the evidences in details, and the parties are not limited in the time, and they may choose a convenient date for the hearing and so on. But on the other hand, it may lead to unnecessary delays in the process. If one party is cheating or preparing something untruth and unfair, so it can use this absence of the law regulation. So, as a result of examination, the arbitral tribunals renders a decision. This decision, as I've said before, is final and irrevocable, and it should be enforced in the General Court of Ukraine, and it can be cancelled. But this information you will know in the next hour lection. So, to sum it up, arbitration is a good way to resolve civil and economic disputes. What are the positive sides? You can tell us. It's the save of money, save of time, and private atmosphere which is during the hearing. So I suggest you to learn more about arbitration, to go to the next lection, and in future to provide a good job for your clients and to arbitrate all the disputes. Thank you for your attention. See you next lection.
Bye.